Through the use of the market capitalization of cryptocurrencies, the DVD provides an explanation of everything. To ensure that I am able to continue airing news about XRP and other cryptocurrencies, I would be extremely grateful if you could like and subscribe to my channel with your YouTube account. Take a look at it this way. In relation to the explosive litigation that Bradley Sostak filed against Ripple, the United States Court of Appeals has made public the crucial dates that Bradley Sostak has disclosed. Due to the fact that the court dates for the XRP litigation were examined, concerns over the shutdown of MidSec appeared. In preparation for the submission of its primary brief, the United States Securities and Exchange Commission (SEC) is working nonstop around the clock. Chairman Gary Gensler has been absent from his office during the entire process. Despite this, there is a possibility of delays occurring as a result of the fact that there are instances in which the government shuts down. That is the way things stand then. Important deadlines that have been set by the appeals procedure of the United States Supreme Court must be adhered to by Apollos. According to the law of the United States, the plaintiff, Bradley Sostak, is needed to have submitted a mediation query by the 23rd of December at that very latest. The transcript of the appeals must be submitted to the court by the 31st of December, and the whole transcript must be submitted by the 30th of January. Sostak will present his opening brief on March 6, 2025, in which he will detail the allegations that he has against Ripple and Brad Garlinghouse, the CEO of the financial technology company. Despite the fact that the deadline is April 7, 2025, you should anticipate receiving a response from Ripple Labs, XRPI, and Garlinghouse. In the event that any of the parties concerned with the appeal fail to satisfy these due dates, the appeal may be dismissed. The most recent announcement made by Ripple comes after a series of favorable verdicts and decisions made by the courts. Bradley Sostak is going to move forward with his allegations regardless of the circumstances. The hold that had been placed on the case was just lifted, and Judge Phyllis Hamilton has recently given her approval to re-examine the verdict. It would have been needless to delay the decision. It is maintained by both sides that the fresh suggestions they have put out were an attempt to find a compromise. Notwithstanding the fact that the class claims were settled earlier, this is still the case. Prepare yourselves for the sultry conclusion. The CCC is simultaneously addressing its own issues while also playing the role of a defendant in the case that is being brought against Ripple. The possibility of a shutdown of the federal government in the United States is growing on a daily basis as concerns regarding the federal budget continue to grow. The Securities and Exchange Commission (SEC) may delay its response to the appeal due to this issue, according to the speculation of certain industry insiders. This would result in a delay in the conclusion of the ongoing legal battle. There is a possibility that Ripple will experience less immediate pressure if this postponement is successful. If a settlement is delayed, it may bring attention to the administrative role that XRP plays. To be sure, according to the announcement, the United States Court of Appeals has decided to move the date of the trial against XRP to a new date. Ripple Labs, XRPU, and CEO Brad Garlinghouse are required to provide a response to the appellant's main brief by the 7th of April of the next year, and the opening brief is due on the 6th of March of the following year. This instruction was included in an appeal that was submitted to the district court. This is a profoundly important new development. After confirming that it has received the notice of appeal, the United States Securities and Exchange Commission is getting ready to file its primary brief before Gary Gensler steps down as chair. This will take place before Gensler's resignation. The United States Court of Appeals for the Ninth Circuit assigned a docket number to the Ripple case. This number was assigned to the case. In accordance with the request made by the Court of Appeals, any future motions that seek relief from this court must be handled in a different manner. A disclosure statement that is comparable to an appeal must be submitted to the United States Securities and Exchange Commission by the plaintiff within 14 days of the date on which they were notified of the situation. As a result of the absence of the necessary documentation, we ought to dismiss the appeal that was filed in the XRP matter before the appeals court. In accordance with the set order, the plaintiff, Brad Sostak, is obligated to submit the mediation questionnaire by the 23rd of December at the latest. On the 30th of January, we anticipate receiving the order for the transcript of the appeal, and on the 31st of December, we anticipate receiving the actual transcript. On March 6th, the plaintiff will deliver an opening brief in their appeals against Ripple and CEO Brad Garlinghouse. These appeals are being filed against several individuals. In response to the appeal, Ripple Labs, XRPE, and Garlinghouse are required to submit their response papers by the 7th of April. Rule 103 of the Ninth Circuit Rules of Procedure stipulates that once hearings have been reported, the parties are obligated to identify the transcripts and, if necessary, cross-designate them. According to the decision of the court, the transcript deadlines do not apply in the absence of reported hearings. As was previously disclosed by COG, the leading plaintiff Bradley Us.Thankx has challenged rulings that favored artificial intelligence, XRP, Ripple Labs, and CEO Brad Garlinghouse. The district court has pronounced Ripple to be the victor in this case. Within the context of the XRP case, Judge Phyllis Hamilton approved the motion to modify the verdict and to delay the order. Due to the fact that the class claims had already been settled, neither party felt it was necessary to request that the court postpone his or her decision regarding the proposed orders. The continuing case between Ripple and SC that is currently being heard by the Second Circuit Appeals Court is the primary focus of the discussion. In the event that the case is dropped or abandoned inside the Bitcoin community, executives from Ripple will be happy. On the other hand, there are many who are worried that issues might occur as a consequence of Gary Gensler's resignation on January 20th, which was 5 days after the crucial short deadline. Despite the fact that the hearings on January 15th are drawing near, Ripple and the SEC have been making headway in their legal battle. John Reed Stark, a crypto skeptic and a former enforcement official for the Securities and Exchange Commission, shared his thoughts on the landmark Ripple rulings in a recent episode of the podcast that is sponsored by Docket Media, LLC. In light of the fact that the Ripple decision does not offer universal legal certainty, he contends that it should not be applied to any other case that does not possess comparable and distinctive characteristics. According to the findings of his investigation into the Ripple ruling, a significant number of individuals made poor interpretations of the verdict because they did not read the paper with sufficient attention. In his opinion, as well as the views of other judges who have reviewed the case on many occasions, Judge Torres was completely wrong on a number of different counts. Despite the fact that I have the utmost respect for the Court of Tories, I must respectfully disagree with her on a number of things. Judge Rakoff and every other court that has examined the Ripple case also held the same opinion. The general public has a complete and full ignorance of the choice about Ripple technology. Stark pointed out that the Ripple verdict could be interpreted in two different ways. At first, he was in agreement with the notion that XRP tokens ought to have been registered as securities when they were initially made available to wealthy individuals. Stark, on the other hand, did not agree with that. You may stay one step ahead of the competition by reading the XRP price prediction. If you are interested in knowing what the probable outcomes of this market-altering legal conflict between Ripple and SEX are, you can read it. On the secondary market, transactions involving additional XRP were carried out. Ripple's decision ended up being surrounded by uncertainty. Regular investors were not protected, according to him, because Ripple does not deal with them directly. He believes that this is an unreasonable statement to make. The argument that he made was that this viewpoint was unfair. As Stark pointed out, this is comparable to purchasing shares of a corporation, which gives the buyer the right to be protected from the legal duties of the company even in the absence of a contract. Stark believes that the Ripple ruling resulted in an excessive amount of confusion, particularly after companies that advocate for cryptocurrency started asserting that tokens were forms of cryptocurrency rather than stocks. With the intention of putting an end to the current procedures, the Securities and Exchange Commission transferred the interlocutory appeal that was filed by OL